Your Honors, this morning, without trying to sound condescending, I'd like to just start out in this case by stating what the law in Florida is regarding impeaching a witness as it relates to this criminal case. In this case, the law starts out by saying we have the Florida Evidence Code 90.608 sub 4, which says specifically in Florida that you're permitted to impeach a witness by showing a defect of capacity. Into the case law.
And what was the defect of capacity you wish to show here?
Judge, in this case, what occurred was that the trial attorney took the victim's deposition ahead of trial, weeks before the trial, and at the deposition, the victim testified under oath that she suffered from bipolar disorder, and that she suffered from this disorder to the extent, not that it was a trivial matter in her life, but to the extent that she received disability payments in lieu of working. So this was a disabilitating disorder from which she suffered.
Did you have any information to suggest that as long as she was taking her medication, she would still have problems?
No, Judge, that wasn't part of the record in this case.
Well, what's your basis then for claiming that this woman had some sort of a perceptual defect simply because she had bipolar disorder?
Well, Judge, my argument would be that I don't need to show that kind of a basis, that my client didn't need to show that.
Of course you do.
Well, Judge, I think that what I would respectfully submit to you, sir, is that when a witness testifies under oath that she suffers from a disorder to the extent that she cannot work and that she receives disability payments in lieu of working and in lieu of holding a job, that she's created the record, she's created the basis for believing, having a good faith belief that this is a disorder that impacts her on a daily level. This was not a trivial problem that she testified to. She testified that she suffered from this disorder to the extent that she could not and did not, she was not employed, and then she received disability. And I think that...
Well, if the bipolar disorder by itself caused her to have difficulty perceiving things, let's say as might be the case of somebody who is not taking medication, sometimes you could have hallucinations or things such as that, that would be one thing. Or if the drug she was taking for it would have interfered with her cognitive ability or her ability to perceive, that would be perhaps an argument that you could make. But if she's taking drugs that make her mind level at the time, what is your argument?
My argument, sir, is that she suffers from this disorder. I think that this is the three-part analysis that we get to when we deal with the Edwards doctrine, where when you have a contemporaneous...
Edwards has to do with illicit drugs.
Yes, sir.
Cocaine or marijuana, I can't remember which, but obviously if you're taking cocaine, let's say, what the court said there is there are three different ways. One, you can be under the influence of drugs at the time of the event that you're perceiving. You could be under the influence of drugs at the time you come to court.
Yes, sir.
Believe me, we've seen some of those.
Yes, sir.
And you could have expert witnesses testify that your brain is so fried that it doesn't matter whether you're on drugs or not.
Yes, sir.
You can't perceive things.
Yes, sir. And I think that what the counter-argument...
That's an illicit drug that would make you lose your ability to perceive things. The drug that this lady was taking, if I understand correctly, it helps her perceive things. Does it not?
Judge, I disagree with that. And what I want to do is I want to first address this Edwards issue. And I think you stated it correctly. And I think that what the third part of the Edwards analysis that you just stated has bled over in this case, and it's being argued to bleed over. We have an admission of a contemporaneous issue. So I don't think we need to get into the analysis. It's just what I think doesn't matter. But what the case law holds is we don't even need to get into this analysis of whether this was such a pervasive problem that everything that this person perceives or does just in general has been tainted by the impact of this disorder. She testified that this was contemporaneous, that she's had this disorder since the 80s and that she hasn't worked in years. So we don't need to get into this analysis.
If you're right, then every single mentally ill person who testifies in court is going to have that revealed in the guise of impeachment.
Judge, it's impeachable, and it's not.
Any person who suffers from any kind of mental illness, any time they go to court, a lawyer can stand there and say, "Isn't it a fact that you suffer from mental illness?"
Well, and Judge, that's not just coming from my argument. This comes from the evidence code. This comes from the rule itself, 90.608
Is there anything in the evidence code that says you can impeach a witness by showing that the witness is mentally ill?
It says by showing, it uses outdated language, Judge. It says by showing a defect of capacity. And the decisional authority, specifically the case law in Florida on this point, specifically goes to diminished mental function. And this is...
That affects the ability to observe, recollect, or recount events.
Correct.
Did
Correct.
you have any evidence to suggest that this woman's, either her bipolarism or the medication she was taking, had any adverse impact whatsoever on her ability to observe, recollect, or recount events?
Judge, I'd answer your question by saying that the defense does not need to present that type of evidence.
Did you have any such evidence?
Judge, I just rely on the supplemental record in this case.
Did you have any such evidence? That requires a yes or no answer.
Judge, in my position, and respectfully, Judge, I think I did. That's my position, is that this evidence is in the record. It's in her deposition, which is part of the record in this case, which was filed as a supplemental volume, Judge. I think if you read the deposition, you'll see clearly that this is not, that we're not talking about some de minimis kind of condition here. We're talking about a debilitating mental illness that this witness has testified to suffering from under oath for years.
Well, if you had expert testimony that she had such bipolar disorder to such a degree that even with medication, she suffered from bouts of inability to perceive things correctly, that would be one thing. But there's not evidence of that, is there?
Judge, and I understand the point that you're trying to make, Judge, and the way I would answer and the way I would counter that point is by saying I don't need to, or my client at the trial level doesn't need to bring in expert testimony on this issue if we have a contemporaneous, if there's not a problem with the temporal relationship. Now, if he was saying this is such an overriding issue that, and you have the case law in this case, where they're cited in both briefs, where we deal with a witness who had hallucinations at one point. It was not contemporaneous. So there was an issue between the defective capacity and the time of the litigated event and the time of the testimony. And what the court said in that case was, yes, that you're going to need to show that there is a big problem, there's an overriding pervasive problem. And that's not the case in what we have in Mr. Hall's case below. That just simply didn't occur. We don't have a problem with the temporal relationship.
Let me ask you whether you have any idea what the common manifestations of bipolar disorder are.
Judge, I'm not qualified to speak to that. I'm just not. I'm not, and I don't, and I think...
And you didn't present anything to the trial judge.
And Judge, I don't think that was necessary because there wasn't a problem with...
Well, let's assume for hypothetical purposes that the principal problems that people with bipolar disorder suffer from if they're not taking medication are mood swings that have nothing to do with their ability to observe or to recount events whatsoever. They just have dramatic highs and dramatic lows.
Correct. And Judge, I would answer that question, I would answer that hypothetical by relating it to a situation in which drugs or alcohol are involved, and by saying that the case law is specific. The defendant doesn't need to put on expert testimony to say, for a witness who, let's say, is taking drugs. A defendant doesn't need, in this case is cited in both briefs, a defendant doesn't need to put on expert testimony to show what methadone would do to somebody's ability to perceive, recall, or recount. That's an issue for the jury.
Or cocaine or marijuana or anything, or even alcohol for that matter.
Correct.
But isn't a drug that clears up your mind in a completely different 180-degree reverse category?
Judge, the case law holds differently. The case law in the state of Florida that applies to this situation specifically addresses drugs that were an issue here. One of the drugs that was mentioned in the deposition in this case was Zoloft. Well, if you look at the cases cited, the Berry case, specifically Zoloft was addressed in that case. In that case, the DCA said that it was appropriately brought out to impeachment.
Did you proffer to the trial judge that the victim was taking Zoloft at the time of the incident?
Absolutely. Absolutely. If you look at, and Judge, I go back again to the deposition transcript that was entered in as a proffer, and it's part of the record in this case. It's the supplemental record. It was offered to the trial court as a proffer. It was specifically argued at the time when this motion in limine arose. So if you look at the case law going further to that point where we have prescription medication issues, well, Zoloft has been specifically, in the Berry case, Zoloft is specifically addressed, and Zoloft is one of the drugs that was at issue here, as per the proffer evidence, Judge. And you go further, Prozac. Prozac specifically addressed in the Traynor case, which is cited in the answer brief. So,
did you cite those cases to the trial judge?
Judge, I believe so, and I have my notes here from that portion of the...
These are cases where they were taking Zoloft by doctor's prescription?
Judge, you know, I read Barry last night, and it doesn't address that. It doesn't address whether that was a prescription.
I mean, you know, if somebody takes, I think if somebody takes too much Sudafed, I mean, I'm not a doctor, but it could put your brain in a position of not being able to perceive things, and maybe too much Zoloft. But isn't a situation where somebody suffers from a mental illness and is given drugs to clear that up, and is taking those drugs according to a prescription in a completely different category from somebody who's just taking drugs?
I disagree, Judge, and I disagree based on a decisional authority, specifically Barry, which was a Zoloft case, Traynor, which dealt with the Prozac, and then there's, I think this, to be honest, this is a little bit different, but there was a prescription pain medication called Hammer, the Hammer case, which is cited in the briefs. So those are three cases where district courts of appeal in this state have held that just because the drugs are prescription drugs, they have held that, you know, these prescription drugs is a valid basis for impeachment under this section of the rule, the section that I raised. So I just want to make that clear that those are three cases where prescription drugs were at least discussed in this decisional authority is a valid basis.
In those three cases, was there not some discussion about evidence having been offered to suggest that these drugs could alter one's ability to? Nothing.
Judge, nothing on that. And I think, and I just want to be very clear, I think that this evidence to some kind of evidence, medical or expert evidence coming in to affirm that this is these drugs will impact somebody's mind in one way or another, I think that goes to a scenario where there's a problem with the temporal relationship, where the relationship between the...
I don't see how it's possibly relevant absent that kind of evidence.
Well, Judge, it's and I go back to arguing in the same context as the street drug and alcohol cases, that it's a valid basis for impeachment.
But everyone knows that street drugs and alcohol alter your ability to perceive and recount events.
Judge, and I agree with that. And I think that it's a jury issue. The issue goes to the jury as to whether these drugs are, whether this impeachment holds water or not. And this was a jury issue that was kept away from the jury in this case. I'll reserve the rest of my time. Thank you.
Hey.
May it please the Court, my name is Tricia Meggs Pate, representing the state of Florida. Your Honor, in this case, the proffer was woefully inadequate to show any type of relevancy, her mental condition or the prescribed medication she was on. They proffered the deposition. All the deposition says is he asked her employment. She said, I'm a housewife and I'm on disability. He said, how long have you been disabled? 61, what's your disability? Since 1991. How long, what is your disability? She said, well, I'm bipolar. How long have you been bipolar? Since 1982. They also established the medications she was taking and that she saw a psychiatrist every 3 months. That's it. That's it. There's no showing that there's a defect in memory. If you read through the deposition, there's no defect in her ability to recount. The victim very adequately describes the events. Her only slightest defect is after the defendant slammed her head into the counter. He held her with his arm over her nose and face, then headbutted her. She ran to the bathroom, and she locked herself in and waited for him to leave because she had no phone or other means of escape, and she can't exactly recount the amount of time she spent in the bathroom. She doesn't know. She thinks it's 10 to 15 minutes. She leaves the bathroom. He comes back in. He yells at her some more. And she can't recount the time after he left before she called his parents and then the police. Those are the only a bit of facts that she can't exactly recall, which I don't think is a product of medication, but not creating the time limit. And I think it would say more to her credibility if she said, yes, I was in the bathroom for 6 minutes and 37 seconds before I vacated. I think that would almost make it more unbelievable. But there's nothing to show that these medications in the record affected her ability to recall. There's no showing in the record that there was an effect on her ability to recall. You have to show something. You have to proffer or present something that shows that her mental condition and the medications she's taking affect her ability to recall, and they never did that. So therefore, based on the arguments in our brief and made today, the state would ask that you affirm.
Your Honor, just to address something that was brought up by the appellee, the appellee relies on this, the unimpugned consistency and credibility of the only eyewitness in this case, but you have to remember that the defense counsel was not allowed to cross-examine the witness in the manner in which he wanted to. So I think it's there's a certain...
You were allowed free reign at the deposition, right?
Correct, correct.
You could have, if, for example, if the facts were that taking these drugs caused her to have periods of time in which she was not able to perceive or recall things, you could have asked her that then and made a record of that as part of your proffer. Correct,
Judge. There's nothing legally that would have prevented that from taking place. Of course, there is, in the case law in this state, will back this up. I mean, a deposition isn't really a cross-examination event. I think.
No, but I think Ms. Pate's argument is that you haven't really proffered the kind of evidence you need to proffer in order to get this impeachment evidence in.
Right, and
because otherwise it's just a slam on the witness's character.
Well, I would disagree with that, Judge. I think that's how the opposing counsel is characterizing what was attempting to take place at trial. But I disagree with that. If you look at when this argument came up as to the motion in limine specifically, you have a trial attorney who sits in front of the trial judge and specifically says, I'm not going to ask her about these other things that we discussed at deposition because those are outside of Edwards. Those are outside of 6084. And he says, I'm specifically going to go to these matters which are within the rule and within the Edwards doctrine. So characterizing the intent of the impeachment is just being a general attack on the witness's character, I think is inappropriate. When you have on the record in this case, you have a trial attorney who says, I'm specifically staying within the rule. There are some other matters. There's these other matters that are outside of the rule and outside of Edwards, and I don't intend to get into that. I just want to get into what's allowed.
You said in your principal argument that this should have been a question for the jury, and I take it you mean by that it should have been allowed so that the jury could determine whether this woman was accurately remembering and recounting what happened. Is that right?
That's correct, Judge.
How would the jury evaluate that issue without knowing whether the condition or the drugs were likely to have some impact on that?
Judge, they would evaluate it the same exact way they would have evaluated if we were dealing with a crack cocaine case. If we had a witness who had taken crack cocaine.
Really? The same way?
Well, Judge, the jury doesn't, you don't have to have an expert up there to tell the jury what crack cocaine does to somebody when you have.
Because everyone knows what crack cocaine does to someone.
Well, Judge, I would disagree with that. Okay. We ask for reversal. Thank you.
Thank you. We'll be in